And that, my friends, is how America was made great once again. Breaking at this hour, Jimmy Sengenberger is currently at the crossroads of politics and economics. Radio broadcaster master, now the celeb on the web. He's the smarty of the party. He's in cahoots with the grassroots. Jimmy at the Crossroads brings you thought-provoking commentary, hard-hitting interviews, original satire, and the best bumper music known to man. Jimmy at the Crossroads!
Gonna talk money, gonna talk politics, great for all generations. Oh, what a great mix, I said. Gonna talk money, gonna talk politics, great for all generations. Oh, what a great mix. I got Jimmy at the Crossroads, making sense out of nonsense. People want answers, they want to understand. They come to the crossroads and Jimmy gives them the plan. I said, gonna talk money, gonna talk politics, great for all generations. Oh, what a great mix. I got Jimmy at the crossroads, making sense out of nonsense. Come on, Jimmy, what you got?
Hello, my friends, and welcome to another edition of Jimmy at the Crossroads. I'm Jimmy Sengenberger, your host for the program. Back in the saddle today, along with me, Nathan Matoush, working the Matoush magic, as we bring you engaging, intelligent talk, Sang style, once again, in partnership with the Washington Examiner, as we indeed, as the great Biff Gore sings, also strive to make sense out of nonsense. Thanks for joining us, being a part of the program. It is such a pleasure and a privilege to be with you today, once again, and on a free-to-choose Friday. Want to remind you, if you have not done so already, please do subscribe to the YouTube channel, youtube.com/Jimmy at the Crossroads. We really appreciate it. Also, be sure to follow me on Twitter, @SangCenter. You see that right on the screen. That's saying with an E, not an A, Center on Twitter. And, of course, the Facebook page as well. Jimmy Sengenberger, media personality, facebook.com/Jimmy Sengenberger Pro. And JimmyAtTheCrossroads.com, the place to go for all the content, to access the shop, the membership program, the Crossroads Club, and so much more. Log on, JimmyAtTheCrossroads.com. And, of course, be sure to follow our friends and partners at the Washington Examiner on YouTube, Facebook, Twitter, and, of course, at WashingtonExaminer.com. And be sure to check out my column from Wednesday in the Examiner and also on the Federalist. Both locations I had pieces on Frederick Douglass and the American founding, the founding fathers, the founding documents. You want to check that out. Plus, I had a piece at Real Clear Markets yesterday about incentives in the economy. So today, I want to jump right into what we've got going on. Free to Choose Friday. Most of what we're doing today will be focused on the United States Supreme Court and its term. We'll talk with Zack Smith, legal fellow at the Heritage Foundation, as well as our good friend Keith Nobles, who's returning because he's a member of the Cherokee Nation. He's a citizen of the Cherokee Nation. Is going to help us break down the Supreme Court decision on Oklahoma. That was pretty darn striking just yesterday. I'm looking forward to that, and I've got some comments to kick things off, but every Free to Choose Friday, what we like to do is remind you why we call it Free to Choose Friday. That's because here on this program, we believe fervently that all human beings are and of right ought to be free to think, free to act, and free to choose. Plus, our patron economist, the late, great Milton Friedman, had a book that he published, very famous seminal economic work and work on freedom, and also a television series back in 1980 called Free to Choose. And speaking of that television series, here's how Milton Friedman would begin it. Gotta love it. It's so retro, so 1980, with more of a 70s feel. You can tell that it's moving in to the 80s. It is indeed Free to Choose Friday. And what do I want to talk about today? Well, there's this debate going on around the country now about reopening schools. The Trump administration is strongly advocating for this. In fact, Secretary of Education Betsy DeVos in Cut 2 was on with Tucker Carlson. I think this is Cut 3, was on with Tucker Carlson last night, and she explained some of her perspective on why the federal government, why the Trump administration is pushing schools to reopen.
So can the Department of Education withhold federal funding to schools that won't comply with common sense and science?
Well, that's definitely something to be looked at. The reality is most of the education funding, as you know, comes from the state and local level. So in excess of 90% of it does. But what the president and all of those at a roundtable today made very clear is the expectation that kids have got to continue their learning. There is no reason to withhold education, full-time education. And I have to give a shout out to Commissioner Corcoran in Florida for putting forward a very comprehensive plan yesterday that had an expectation that all students would be able to be back in school in person 5 days a week, and then giving a lot of latitude as to how schools deal with special situations. You know, I think if nothing else, this whole coronavirus has made more and more parents aware of what's going on in their own children's schools or what isn't going on. I think right here in suburban D.C., one of the most elite public school districts in the country, over $16,000 per student per year. They had an absolute disaster this spring. And now this fall, they're suggesting that as a way to start school again, you can choose 0 days a week for your child to be in school or 2 days a week. That's not a choice. That's a pretense of a choice. So more and more families are at a point of demanding that their kids could be able to continue to learn, and they want more options and choices for their kids too.
For years, I have said now that Betsy DeVos is the best Secretary of Education that we've had since Bill Bennett in the 1980s, and I think she reaffirmed that in her interview with Tucker Carlson and with other interviews. She's absolutely right, but today I don't want to be focusing on reopening schools and that debate. I think we'll get to that in greater detail next week. What I want to focus on is something that is always striking when Democrats bring up the United States Constitution, especially in the context of federalism. Let's go to Cut 4 here. Governor Andrew Cuomo of New York, in a press conference, I think yesterday, blasted the Trump administration for proposing the idea that they would force states to reopen their schools. But also in the process of doing so, he made some claims about this thing called the Constitution. Take a look.
And I heard what the president said on schools, but this has been there, done that, right? School reopenings are a state decision, period. That is the law, and that is the way we're going to proceed. It's not up to the President of the United States. There is something called the Constitution that guides government power, and then there are a series of laws that are based on that Constitution. And the President does not have the authority to open schools.
The President does not have the authority to open schools. Moreover, there's this thing called the Constitution that gets in his way. Cuomo went a step further as well.
Just to be clear, the federal government has no legal authority when it comes to school openings.
The federal government has no legal authority. Notice he brought in that out. That's not just President Trump. The federal government includes the Congress of the United States. I do have a copy of the U.S. Constitution right in front of me, as well as the Declaration of Independence, and maybe he's right. I'm struck by this notion of a great constitutional awakening when we see Democrats, folks on the left, say, well, you know, the federal government doesn't have this authority. States' rights, federalism. The Constitution doesn't allow that. It actually puts limits on federal power. The Great Constitutional Awakening? Probably not. But let's put this to the test for a moment. Cuomo says Trump, and even more, the federal government itself, more broadly, has no authority, no legal authority to force schools to reopen, even by tying federal funds to the reopening. What I'm wondering as I flip through this Constitution, and I'd like to ask Mr. Cuomo this, where does the federal government even get the authority to have a federal Department of Education in the first place? Inquiring minds certainly want to know. I can't find it in this thing called the Constitution, where it actually authorizes the power to set up a federal Department of Education, or a heck of a lot of things that the federal government does. I would like Governor Cuomo to explain to me where this authority comes from for the Department of Education in the first place. And maybe he'll agree with me that it's not there in the Constitution, and therefore we should eliminate the federal Department of Education. I doubt that he would answer it that way. He'd probably find some sort of justification for that. I'm not going to hold my breath waiting for an answer. In the meantime, Governor Cuomo opened the damn schools back up. It's time. We don't have enough time to really play the long clip, but I do want to play a short clip in cut 7 of Dr. Scott Atlas of the Hoover Institution, where he was just strongly advocating, and he's been for weeks now, that schools plan to reopen in the fall because the science, as he points it out, the science is clear that kids are not at risk for this virus, even spreading this virus. And also, he thinks, look, the school teachers can take precautions, and you can actually have the school teachers stay home if they are most at risk and maybe teach remotely and figure out a way to do that, versus having kids not go to school and face all the consequences. For example, he likes to point out that school is a place where abusive home situations are often detected. The most often situation for that. Schools are the situation where kids' eye problems are identified. I know that from my own experience. And the list goes on and on and on. Mental health, physical health, all sorts of things, school lunch programs. But Dr. Atlas also points out that guess what? Schools are an essential business.
Because the data is clear, whether it's from Canada, Switzerland, Sweden, the Netherlands, France, Spain, the United States, Asia, all over the world, children do not have any serious disease. Children almost never transmit the disease. In fact, Switzerland is contemplating stopping.
Okay, wrong clip, actually. Let's play the other one real quick.
Aren't schools an essential business? Are these teachers telling me they never go into a grocery store? Are these teachers telling me they don't do any other essential activities? Schools are essential businesses. I mean, this is really inexplicable to me. I think it's really going to be one of the most heinous, egregious examples of absolutely wrong public policy historically when we look back at this era. It's very harmful. We are destroying children here. And if children aren't an essential business of the United States, there's something wrong with this country.
Absolutely right. We'll talk more about reopening schools next week. But I'm going to continue to watch for the great constitutional awakening on the left to continue to expand. And maybe they'll really understand the principles of federalism and become strong advocates for it. I'm Jimmy Sengenberger. We are overdue for a break, coming to you in partnership with the Washington Examiner. When we return, we will be joined by Zack Smith, legal fellow at the Heritage Foundation, as we break down the current Supreme Court term that just wrapped up yesterday and its impact on American freedom. Keep it right here, Jimmy at the Crossroads. I'm Jimmy Sengenberger.
Hello, Jimmy. This is President Ronald Reagan, calling from the great beyond on your hotline. It's a different number than the one I used to contact Mr. Gorbachev, but it's no less important, especially at this kind of time. Well, Nancy and I, we stay on the ranch now here in heaven, and we're your biggest fans. We sit out on the porch there, and I'll have my Nancy, bless her heart, she makes me some tea, and we listen to your show. Every minute of it. We fully support you in what you're about to accomplish in the future. Nothing but peaceful progress. Some people say, well, what will Jimmy do now? Well, stand by, because you're going to see some real fireworks. This young man has so many great ideas, and so forth. Why, I hate to interrupt, Ronnie, but let me just say this about that. I couldn't agree more with the way that you and Nancy feel about this entire thing. Jackie and I have been observing and listening to the Sengenberger show, and with regards to that, he's on the edge of a new frontier. No looking back, and I declare that by the time this decade is out, he'll have a syndicated show that will spread all the way across the universe. Oh, well, Jimmy, that was Jack Kennedy. He likes to get every word in edgewise. I tease him a lot. He likes to go out on my boat there and tool around on the sailboat. Well, Nancy brings him lemonade. He enjoys it. Yes, we're both, all of us are big fans. Oh, well, Jimmy, it seems that Nancy's ringing that old chuck wagon dinner bell, and it's time to go get all the fixins. Coming, Mother. So, we'd just like to say congratulations. Well done. In closing, I'd like to say that if you ever run into an obstacle that seems too big or too daunting, well, I'll say this. Mr. Sengenberger, tear down that wall.
America's politics are crazy. The culture is in flux. That's why we work hard to help you keep up.
More politics, more culture, and more access.
We focus on the biggest stories of the day with some of the biggest names in politics and punditry.
Go to our website, WashingtonExaminer.com. Subscribe to our YouTube channel. Be sure to follow us on Facebook, Twitter, and Instagram.
And ladies and gentlemen, welcome back to Jimmy at the Crossroads, bringing back Funkytown here on the Crossroads on Free to Choose Friday. Jimmy Sengenberger, he's ready to go, set to bring on Mr. Zack Smith from the Heritage Foundation. Jimmy Sengenberger, folks.
And Nathan Matoush, producer extraordinaire, working the Matoush magic once again here on Jimmy at the Crossroads, coming to you in partnership with the Washington Examiner. Happy Free to Choose Friday. So great to be with you today once again. And yes, in just one moment, we will be joined by Zack Smith of the Heritage Foundation and their Mies Center. But first, I want to play a Friedman clip. This is the one clip we've got today since we're focusing on the United States Supreme Court. It's one from a speech in the 1970s where Milton Friedman was talking about the role of government in a free society. Why do we have a government? What is its principal role?
The fundamental principle that I am going to try to uphold was stated by John Stuart Mill in On Liberty over 100 years ago. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. That's the fundamental principle that I am going to take as a given as describing my own values in trying to discuss the question of what government's role in a society dedicated to promoting freedom in that sense what its role is.
Government fundamentally, its role under the Constitution and guided by the Declaration of Independence, its Constitution, our Constitution, lays it clear that the fundamental role of government is to protect individual rights. Let's talk about the Supreme Court's term that just wrapped up yesterday with Zack Smith. He's a legal fellow at the Heritage Foundation's Edwin Meese III Center for Legal and Judicial Studies, and he joins us now here on Jimmy at the Crossroads. Happy Free to Choose Friday. Welcome to the show, Zack.
Happy Friday, Jimmy. Thanks so much for having me on. I really appreciate it.
It's great to have you. I mean, the Supreme Court just wrapped up their term yesterday, and I thought, look, how about we talk a little bit about this term and how it is impacting American freedom? Seems like a perfect topic on a Free to Choose Friday. But before we dive into this term, let's go to Civics 101 for a moment and refresh on why we have a judicial branch in the first place, Zack Smith.
Sure. We have a judicial branch to decide cases and controversies between individuals in the government, or even between different branches of government. And so if you go all the way back to the very beginning of the judiciary, in a famous case called Marbury v. Madison, Chief Justice John Marshall said, "It's the duty of the judiciary to emphatically say what the law is." And so that's really the gold standard for what we want our judiciary to do. We want them to apply and interpret the laws that are presented to them and not to make new law out of whole cloth. And so hopefully with many of the good recent appointments that President Trump has made, more and more of our judiciary will hopefully take that view and be committed to interpreting the law instead of making new law from the bench.
Yeah, it's so important, and that is critical as well when we're talking about American liberty. Protecting American liberty means that you actually follow, and I got it here, the United States Constitution, and make sure that you are abiding by it in making these particular determinations. And I would contend, and I'm sure you'd agree with me,
Absolutely.
that time after time, the Supreme Court of the United States as well doesn't get it right all the time. They get it wrong oftentimes as well.
That's true, Jimmy, unfortunately. And, you know, we've seen that this term, in fact, we've seen a lot of encouraging decisions that will protect individual liberties, individual freedoms, but there were also several significant missteps this term as well. And so, you know, with the good comes the bad, but fortunately this term, there was more good than bad. And I think we ended the term on positive notes that protected individual freedoms and specifically protected religious liberty in several important areas.
That's a great setup. Let's dive right in. Again, Zack Smith, our guest from the Heritage Foundation. And let's start with the religious liberty topics, because this is something that has been on the minds of many Americans in recent years because religious liberty has been under assault. When we look at the Supreme Court, one of these cases dealt with the contraception mandate and the Trump administration giving exemptions, for example, to the Little Sisters of the Poor in that regard. And there were a couple other cases on religious liberty as well. Go forward.
Sure. So there were really three big religious liberty cases this term, Jimmy, that are worthwhile to talk about today, I think. And, you know, if we kind of piggyback on your first segment where you talked about schools, in fact, one of the biggest religious liberty cases from this term involves schools and school choice and the type of funding that states have to provide. You see, a lot of states have something called Blaine Amendments. They were adopted in the late 19th century, really to discriminate against Catholics and Catholic schools. And they said that you couldn't use public funds to pay for any parochial schools, essentially. And so this issue has been litigated before. And fortunately, in a case called Espinoza v. Montana, this term, the Supreme Court said those types of requirements that you can't provide funding to parochial schools on the same basis that you do on any other schools, well, those types of requirements are unconstitutional and discriminatory. And so that's an encouraging step and will likely cause many states around the nation to have to reevaluate their policies if they have similar amendments or similar rules in place for their school funds. The second big case that I think is worthwhile talking about is one you mentioned as well, the Little Sisters of the Poor. You know, at this point, many of us are very familiar with the Little Sisters. They're probably the world's most tenacious nuns. They've been fighting against Obamacare's contraceptive mandate almost from the very beginning. And so what we saw starting in 2011, when Obamacare was passed, HHS put in place some very onerous mandates that essentially required employers, private employers, nonprofits, even certain religious groups to provide contraceptive coverage to their employees, even if that violated their strongly held religious beliefs. And there were some exemptions, but the argument was those didn't go far enough. And so we had the Hobby Lobby case in 2014 that applied those exemptions to closely held businesses. We had another case in 2016 called Zubik v. Burwell, where the court basically punted on the question and said, you know what, little sisters, HHS, you need to go work this out. And so what we saw in this case is essentially the 2016 election, the Trump administration came in, passed very protective measures for groups like the Little Sisters, and several states such as New Jersey and Pennsylvania weren't happy with those new accommodations, and so they sued the Trump administration. And what the Supreme Court did here, they said basically, look, the process that the Trump administration used to pass those regulations was appropriate, and they were also appropriate under the Obamacare statute. And so basically, they sent the case back to the lower court to continue litigation. So it's not the final say on the issue, but it is an encouraging step in the right direction. And then finally, on the religious liberty front, a very encouraging case came down that basically said, you know, it's up to religious schools to determine who's providing religious education, and that other non-discrimination laws can't effectively override a religious school or a religious organization's determination about who is providing religious instruction, and more importantly, what that religious instruction will be. And so overall, this term on the religious liberty front, it's been very encouraging and will hopefully continue a trend of protecting our rights to freely exercise religion in the United States.
Let's stay on these positive decisions. Zack Smith, again, our guest from the Heritage Foundation. Something else. This one you were saying is a little dry, but hey, it's pretty important when we're talking about federalism and states' rights. There was a copyright case that was decided by the Supreme Court this term. Tell us about that one.
Yeah, that's absolutely right. And it's actually, it's dry, but it has some interesting facts. It dealt with Blackbeard's ship and Blackbeard's treasure. And essentially what happened is a photographer took some pictures of Blackbeard's treasure that he recovered, and the state of North Carolina wanted to use those pictures without paying him. And he said, wait, you can't do that. I have a copyright. If you're going to use them, you have to pay me. State of North Carolina said, no. We're a sovereign entity, a state. We can use it if we want to. And so basically, it devolved into technical issues about copyright law. But what the Supreme Court said here importantly is that in passing the Copyright Act, Congress did not abrogate state sovereign immunity. And state sovereign immunity is a very important federalism principle because it basically says that states are separate sovereigns and they can't be sued by other individuals without their consent. And that if Congress wants to allow them to be sued, they have to do so very clearly and very explicitly. And so overall, it had some unique facts about Blackbeard's ship, Blackbeard's treasure, but it was a win for federalism in the sense that it protected state sovereign immunity.
Yeah, we are hearing about a resurgence, at least in the minds of some, of federalism as being important all of a sudden, as I was talking about in my monologue. So hopefully that expansion will continue, and people will say, you know, these rulings affirming federalism and the role of the states under our Constitution, they're pretty good. Hopefully we'll hear more politicians who often don't stand in that way for those kinds of approaches to government will open up a little bit more in that regard. Let's talk about the Consumer Financial Protection Bureau. This was a program that was established by the Obama administration under the Dodd-Frank law that deals with the financial sector, particularly reforms intended, supposedly at least, for the aftermath of the financial crisis and to address some of those regulatory issues. But there have been a lot of questions, a lot of scrutiny that has been placed upon the CFPB from a political context in Congress, and also the Supreme Court here took it up in a court case. What's going on here?
Sure. Well, you're going back to Civics 101, like you mentioned at the beginning of the segment. We have three branches of government: the judicial branch, the legislative branch, and the executive branch. And what Congress tried to do with the CFPB is essentially insulate the agency from the political process. And so it gets funding from the Federal Reserve System, which itself has a unique source of funding. And so it's not really dependent on Congress to get funds to run its operations, which, the founding fathers said the power of the purse is one of the most powerful incentives that Congress has. And on top of that, it also had a unique structure in the fact that there's a single director at the head of this agency. There are other supposedly independent agencies in the federal government, like the SEC, the Securities and Exchange Commission, the Federal Trade Commission, but typically those entities have multi-member commissioners. And so the idea is that if you're going to make it an entity or a commission less politically accountable, typically those have taken the form of multi-member agencies. The CFPB, by contrast, had a single director that could potentially survive and function independent of whoever's in the White House. And so what the court did in the CFPB case, in a case called Seal of Law, is they basically said the fact that the CFPB has a single director at its head is unconstitutional because we have a unitary executive. The president is the head of the executive branch. Now, what they did, they basically severed that unconstitutional portion of the statute from the rest of it. And so the CFPB remains in place as an entity, but structural reforms will have to take place in order for it to survive constitutional muster after the Supreme Court's decision.
Once again, Zack Smith is our guest from the Heritage Foundation Legal Fellow there in the Edwin Meese Center. Let's shift gears here with you, Zack, to a few Supreme Court cases that were, shall we say, not very much in step with individual liberty. And I want to start with a gun rights case. And this one is particularly striking to me, but it's the case of New York State Rifle and Pistol Association v. the City of New York. Set this one up for us.
Sure. And the court's decision in this case was disappointing in a lot of ways. But essentially, New York City had a regulation in place that said if you were licensed to have a firearm in your home, you couldn't transport that firearm out of state. And so this presented really significant practical problems for most of the gun owners in New York City, because most of the firing ranges available to individuals to practice, to get certified, were in fact in the suburbs and out of state of New York. So they were in New Jersey, Connecticut, and there were very few ranges available in the city itself. And so what happened is a bunch of gun owners got together, they challenged this rule, filed lawsuits saying it was unconstitutional. Well, after the lawsuit was filed, but before the Supreme Court could rule on it, the city of New York changed the rule. And so because the city of New York changed the rule, the justices looked at the case and said, look, this is a moot issue. New York City changed the rule. And so we're going to dismiss the case. Now, the problem with that approach, seems obvious, is there's nothing to prevent New York City from changing their minds and changing the rule back again. And so it was disappointing to see the Supreme Court take this approach. But I think we do have the potential to see several other Second Amendment and gun rights cases percolate their way up through the lower courts and become ripe for the Supreme Court to review in the next several years.
And we talked, Zack Smith, on this program before with the previous guest about how the Supreme Court actually really declined to take up and make decisions on 10 different cases before them dealing with gun rights issues. There are controversies, these cases and controversies all across the country where you have a patchwork of differing perspectives from different courts on how the Second Amendment should be interpreted. And that's very troubling. I hope that these court cases that are working their way up will actually be taken up by the Supreme Court, but I don't know how likely that will be or why they haven't been doing so in what I would say is a very appropriate and constitutionally centric way, Zack.
Yeah, that's absolutely right, Jimmy. And, I don't know, all we can really do is speculate about why the court is not taking up these gun rights issues. But I think it is important that the Second Amendment is a fundamental right. It is an individual right that is co-equal with any of the other rights that we as Americans hold. And so what we're seeing is in lower courts is some judges, especially recent appointees, are saying, look, the Second Amendment is an important right, and we have to treat it in the same manner as we would any other individual fundamental right. And so seeing those decisions in lower courts are encouraging, and hopefully will encourage the justices to take up these Second Amendment cases when they come before them and really enshrine that principle and say that the Second Amendment is a fundamental right. And if the state is going to infringe on it, they have to have a compelling reason to do so.
Yeah, absolutely. And I do want to share that until recently, I was heading up a think tank of my own called the Millennial Policy Center, and we actually filed a Supreme Court brief. Our legal fellow Joe Greenlee did this along with Dave Kopel of the Independence Institute, that was joined by several professors of Second Amendment law, the Second Amendment Foundation, and several others. So I do want to throw that out there in terms of this case. I'm especially disappointed in the outcome. Zack Smith, again, our guest from the Heritage Foundation. One other case that we talked about was the Bostock decision dealing with the LGBTQ discrimination in the workplace that a lot of people were heralding as an achievement of individual liberty and so forth. But I'd like for you to sum that up. Let's talk about it for a moment again, because this is one case on not a constitutional grounds, but on the legislative text grounds and the idea of textualism that a lot of folks say the court got wrong. And Gorsuch, by the way, an appointee of President Trump's, was the writer, the author of that opinion.
Right. And, Jimmy, this was a disappointing decision on several grounds, but especially because it was pushed forward as a textualist decision. And so essentially what Justice Gorsuch wrote in his decision is that because the word sex, that individuals, entities can't discriminate against someone on the basis of their sex, that term really encompasses all aspects of sex. And so he said that individuals can't be discriminated against on the basis of if they're homosexual or if they're transgender or any host of other characteristics such as those. And so it's really a radical departure from the way that Title VII statute has been understood for the past half century or so. And I anticipate it will certainly lead to a significant increase in the amount of litigation in the Title VII arena. And it also, most troublingly, has a great potential to infringe on the religious liberty of individuals who have sincerely held religious beliefs against either homosexual lifestyle or transgendered lifestyle. And so it's really important that now that the Supreme Court has gone down this path of saying that same-sex attraction, transgendered status are protected characteristics under Title VII,
Sure.
that appropriate protections are put in place for religious individuals as well.
Let's talk about one more case, June Medical Services, this decision dealing with the Louisiana abortion law. Real briefly, Zack Smith.
Sure. So basically, Louisiana passed a law requiring abortion providers to have admitting privileges at local hospital, a perfectly reasonable and rational decision to protect the health of everyone involved in the abortion procedures. The Supreme Court said this rule was unconstitutional because it unduly infringed on the right of women to receive an abortion. And what was surprising and again troubling about this decision is that the Chief Justice wrote the decision in this case declaring that law unconstitutional. But 4 years ago, in 2016, in a very similar case out of Texas, he actually dissented from that decision and said that he believed these types of laws were perfectly constitutional. He changed his position here because he said on the basis of something called stare decisis, basically to saying the court's already decided the issue and it has to stand. Now that's troubling because if he thought that these rules were constitutional 4 years ago, surely there's no way that he now thinks they're unconstitutional. And so the idea that an unconstitutional decision could stand is troubling, to say the least.
And final question for you, and this is on a separate case we're going to talk about more with our next guest, Keith Nobles, in Mcgirt v. Oklahoma. The court decided yesterday that a significantly large portion of Oklahoma land belongs to Indians. Tell us what this decision, kind of synopsize it so we can set up for the next segment.
Yeah, that's right, Jimmy. And when you say a significant portion, you're really talking about half the state of Oklahoma, the entire eastern half. Some 2 million people now live on land that are part of an Indian reservation. And so this is one of the least talked about decisions, but probably one of the most significant decisions to come out of this term. And so basically what the court said, again, in an opinion by Justice Gorsuch, is that Congress never disestablished certain reservations that it had set aside for different Indian nations in the territory of Oklahoma. And because they never clearly disestablished those reservations, they still exist. And so technically speaking, this was a narrow decision dealing only with certain criminal procedure aspects. But, there are at least somewhere close to 2,000 potential convictions that are now at risk in Oklahoma. But more importantly, the dissent that Chief Justice Roberts wrote pointed out this decision could have very broad implications in many areas, including property ownership, family law, taxation, administrative law issues. And so I think we're really going to see a lot of litigation over this in the next several years. And it will certainly be interesting to watch and see how this plays out and if congressional action may even need to take place.
How did this particular decision break down among those of the court from sort of an ideological standpoint?
So it was a unique lineup. You had Justice Gorsuch writing the decision with the 4 justices who are typically considered to be the liberal wing of the court, Ginsburg, Breyer, Kagan, and Sotomayor. And then you had Chief Justice Roberts writing the dissent. And he basically said, how everybody for the past 113 years has thought this land was part of the state of Oklahoma. How can it now suddenly be tribal land? And so Roberts wrote the dissent, and he was joined by the 4 typically conservative justices, Justice Thomas, Justice Alito, and Justice Kavanaugh. And so it really was a unique breakdown, but it certainly has the potential to have some of the most far-reaching consequences of any decision we've seen handed down this term.
And we're going to talk about some of the implications with Keith Nobles in the next segment. Here's one final question for you, Zack Smith. On the whole, looking back at this 2019-2020 term, which of course will be marked in history as including the first telephone hearings, oral arguments rather, of the United States Supreme Court, but also some very significant decisions. How do you break this one down from sort of a general standpoint and then the American liberty and protecting American liberty standpoint on the whole?
Well, I think the big positive story coming out of this term is religious liberty. There were huge wins for religious liberty this term, which are very encouraging and hopefully will be a trend we continue to see. The justices are taking a very broad view of free exercise rights of Americans. And so hopefully they'll continue that and eventually overturn a problematic decision called Employment Division v. Smith. As we mentioned a few minutes ago, with the good comes the bad. And so I think the Title VII decision was a very disappointing decision for a lot of us, especially because it was couched in textualist terms. Now, I think there are some issues with the way that Justice Gorsuch went about his analysis, but it was a disappointing decision. And then also, again, the Second Amendment decisions and the reproductive rights decisions out of Louisiana were very disappointing. And so hopefully the Supreme Court will revisit those issues in the next term or in the next several terms and kind of right the ship where they went wrong this past term.
We shall see what happens, to be sure. Zack Smith with the Edwin Meese Center at the Heritage Foundation, legal fellow there. So great to check in with you to break down this important term of the United States Supreme Court. Thanks for taking the time.
Thanks so much for having me on, Jimmy. I really appreciate it. Take care.
Thank you, and happy Free to Choose Friday, by the way.
Thanks. Happy Free to Choose Friday to you as well.
Thank you. Once again, Zack Smith with the Heritage Foundation joining us here on Jimmy at the Crossroads. In just a bit here, we will be joined by none other than good friend of the show, Keith Nobles, on the program to dive in a little bit more into the Indian Territory decision, the Indian Reservation decision of the Supreme Court vis-a-vis Oklahoma in the case of Mcgirt v. Oklahoma. He is a citizen of the Cherokee Nation and will be able to go through particularly some of the implications of this decision, what it really could mean moving forward. We've got that and so much more coming up here on Jimmy at the Crossroads. I'm Jimmy Sengenberger in partnership with the Washington Examiner.
Crikey, that was the biggest bloody mosquito I've ever seen. Wait, coming in. Oh, good day, mate. You know, after a long day of kangarangling and croc roping, a man can really work up an appetite. Not to mention a whopper of a backache. I know a place, and that's why I like coming into the Back Out Steakhouse. The Back Out is the only place I know where you can sit down in a lumbar support barca lounger and enjoy a big juicy bandicoot steak or a thick koala chop served by a licensed chiropractor. And as you partake of your meal, your server will provide you with a spinal manipulation, neck twist, the hip alignment, the full Matilda. One visit to the Back Out Steakhouse and your spirits will return like an Abbo's boomerang. So the next time your back goes on walkabout and you're coincidentally, simultaneously craving a slab of cooked meat, waltz on into the Back Out Steakhouse. You not only feel good down under, but all over. Back Out Steakhouse! Good stuff, eh, Skippy? Bloody boomerangs. Back Out Steakhouse!
Hey, this is Frankie.
Hey, and I'm Angelo. We're the owners of F&A Pizzeria. If you're looking for the best pizza in town, remember us. F&A.
Hey, we got the best crust.
F&A.
We got the best cheese.
F&A.
We got the best sauce.
F&A, man.
Put it all together, what do you got?
F&A.
Yeah, you got that right. F&A.
F&A Pizza on the corner of Hill Ya Avenue and Dam Straight Street.
You're an entrepreneur.
I'll give you the alternative.
You're an entrepreneur.
Sure.
You've got to create 30 million jobs over 3 years.
Yeah.
Tell me what companies can do that.
So, first
tell me
of
what
all,
20 or 50 or 100 companies can do that.
I can't tell you a specific companies that can do that because I don't know. In fact,
or investors.
But
Pick the greatest investors of
right.
all time.
Well, but I don't presume to think that I know who's going to be the best investor, the best company to do that. Just as I don't think the government is, that I could presume that the government's going to be effective to do that.
Gonna talk money, gonna talk politics, we're for all generations. Oh, what a great mix, I said.
Has been on a determined campaign to convince the world that everything is hunky-dory. And when the government actually spends so much effort trying to convince you of something, you got to be very suspicious.
Your lawyers don't tell you even all the evidence that the government has given them, the few meager disclosures that were made literally at the 11th hour after you'd already been coerced into pleading guilty.
Hours of video evidence of Nancy Pelosi coming up on your porches and jujitsuing your precious packages, while Chuck Schumer waits in the street in the getaway van because he's too afraid to be a man and do his own dirty work.
Come on, Jimmy, what you got?
Is it scary that YouTube and Twitter and Facebook have this kind of power over us? Of course it is. But you know what? These things didn't always exist, and they won't always exist. David beat Goliath. The little guy can beat the big guy.
So we have to figure out ways to fight in which we are able to have that kind of reach. We can build our own megaphones. And this is a little bit of a longer term project. It goes beyond Trump's re-election because it affects every election.
I'm good, man. It's a partnership. We're like this, Jimmy. I got you.
Jimmy, can I tell you that I've done about 200 shows in the last 3 weeks for this book tour? This has been by far my favorite interview.
And that, my friends, is how America was made great once again. Breaking at this hour, Jimmy Sengenberger is currently at the crossroads of politics and economics. Radio broadcaster master. Now the celeb on the web. He's the smarty of the party. He's in cahoots with the grassroots. Jimmy at the Crossroads brings you thought-provoking commentary, hard-hitting interviews, original satire, and the best bumper music known to man. Jimmy at the Crossroads!
I got Jimmy at the crossroads, making sense out of no sense.
And now, the further future adventures of Starship Winkler. In today's episode, the captain is making travel plans.
Sparks, open up a frequency to price expediosity line.
Yes, Captain.
Hello, and welcome to Price Expediosity Line. How can I help you?
Well, I'll need a room.
Are you traveling alone?
Yes.
Oh, that's a shame. Never found the right woman, huh?
Well, there was this... No, wait, just book me a bed.
King, queen, fool, twin, Murphy, or bunk.
King. You never know.
Well, as long as you're convinced. All right, name your price.
Name my price?
That's how it works. Name your price.
$6?
$6 it is. Let's plug it in here. Bippity, boppity, boo, and... Sorry, you were outbid.
By how much?
Penny. Someone bid 6. Oh, 1.
Who?
Oh boy, I just booked a room for $6.01.
Well, will the captain ever make a good bed bid? Tune in next time when we hear...
Here's one for $602.
I'll take it.
$1,000.
Oh, damn dramatic pauses.
On Starship Winkler.
Do you wear a toupee? Do you yell out, Spark? Do you put in pauses when you talk? Do you start real soft and then go real loud? Have you won 2 Emmys? Do you love a crowd?
Whatever makes you feel like a Shatner. Yeah, you got lots of macho and swagger. You had alien affairs. You sing bad but no one cares. You find low airline fares. If you like to work, got a handsome smirk. If you're Captain Kirk, whatever makes you feel like a
Me. Phasers on. Stunning. Whatever makes you feel like a Shatner.
We haven't had a little Shatner time here on Jimmy at the Crossroads in quite a while, so there you go. It's Free to Choose Friday. We're having fun, and we're sort of trying to feel like a Shatner right about now. Welcome back to Jimmy at the Crossroads, coming to you in partnership with the Washington Examiner. I am Jimmy Sengenberger, and it is such a pleasure and a privilege to be with you today. Once again, thanks for joining us. If you have not done so already, please be sure to subscribe to the YouTube channel, youtube.com/Jimmy at the Crossroads. Also, follow me on Twitter at Sang Center. You see it right here, Sang with an E, not an A, Center on Twitter. Like the Facebook page, Jimmy Sengenberger, media personality at facebook.com/Jimmy Sengenberger Pro. And you can get access to all those social media locations, content, the shop, the Crossroads Club membership program, and more at jimmyatthecrossroads.com. Be sure to check it out, and also to like, subscribe, follow, all those good things for our friends and partners at the Washington Examiner on YouTube, Facebook, Twitter, and of course at WashingtonExaminer.com. So it is Free to Choose Friday today, and we are focusing in on the Supreme Court and its impact on American liberty. In the last segment, we talked with a legal fellow at the Heritage Foundation to break down a number of cases, and the final case that we delved into was the one called Mcgirt v. Oklahoma, and we will get to that momentarily with Keith Nobles, who is a good friend of the program. He is author of the novel Our Dogs Did Not Bark, a politically incorrect dystopian tale. Keith is also a citizen of the Cherokee Nation. and has some excellent insights to share momentarily in Mcgirt v. Oklahoma. And Keith Nobles joins us now here on Jimmy at the Crossroads. Keith, welcome back to the show, my friend. Good to have you here.
Good to be back. How are you?
You know, I'm doing pretty well. Happy Free to Choose Friday.
Happy Free to Choose Friday.
Now, I have to show something. So, first of all, Nathan Matoush, put up Keith on the full screen, please. No lower third. Let's get a look at the T-shirt that he is wearing. Not yet at peak absurdity. And not only that, put up the picture, please. We have these T-shirts available for you at shop.jimmyatthecrossroads.com. Right there, you can see we've got men's shirts, women's shirts. We've got the camper mug as well. And it is in reference to something that Keith in our circles is pretty famous for. This idea that is, you're often asked a question, Keith, are we at peak absurdity yet? And your answer,
No,
of course, is
no, we're not.
Not
yet. Peak absurdity.
Exactly right. Tell us about that for just a moment so people can have a little bit of context for the product available at shop.jimmyatthecrossroads.com.
Well, James Kunstler, the novelist and blogger, a little more than 4 years ago, February of 2016, I believe, posted a phrase that I reused a lot. That sometimes societies just collectively go insane.
Right.
And part of that insanity is the continued absurdity we see in public life. You don't have to stray any farther than Twitter or Facebook or any of the social media platforms to see it every day. We continually become more absurd. We are continually more detached from reason, from sanity, from what makes sense. And it's been kind of a competition. People for about 4 years have been asking me, are we at peak absurdity yet? And I keep saying, no, we are not. But 2020 may be the year we hit peak absurdity. Let's hope this is the year. Let's hope it doesn't get more absurd than it will be by the end of this year.
So in other words, what you're suggesting, Keith Nobles, is that these T-shirts, not yet at peak absurdity, by the way, saying Keith Nobles, referencing you there, that they may have a shelf life.
Oh, yeah.
Or should we say a dresser drawer life? All right. Well, I hope not. I hope they could. Well, actually, I hope so. For our society, for our sanity, I certainly hope that eventually we reach peak absurdity. Once again, Keith Nobles, our guest, joining us here on Jimmy at the Crossroads. Check out his novel, Our Dogs Did Not Bark, a politically incorrect dystopian tale. All right, Keith. Mcgirt v. Oklahoma. You are a citizen of the Cherokee Nation, so you have a strong interest in this. I know you've been to Oklahoma many times. I want to ask you right off the bat to set the table for us, before we get into any opinions and some of the implications, set the table for us on this decision and what it entails. And I know that this goes back to, really gives, a couple hundred years of history in the mix.
Yeah, and as you know, I have spoken and written about this very issue for a very long time. So roll back to the Constitution being adopted, roll back to George Washington being the first president. The parts here of the Constitution that are relevant to this case, to this matter, are Article 1, which is the sovereignty of the nations, that Indian nations should be self-governing under the Constitution, and Article 6, which are treaties are the law of the land. So these are the guardrails. George Washington, being the first president, had the first Indian policy, and that Indian policy was he invited Indians into the family. He invited Indians in to become Americans. This is very important. So as a Cherokee, the Cherokee Nation, we were the first tribe to accept this offer. We sent Major Ridge, a prominent Cherokee, to the White House in 1807, and he told Thomas Jefferson, we accept your offer to become Americans. And from that point on, Cherokees clung to being Americans. So this offer extended through the early presidencies, the early administrations, for Indians to become Americans. And this was the American policy. Andrew Jackson revoked that policy, revoked that offer. This is why Indians do not like Andrew Jackson, because Andrew Jackson basically said, I take the offer to become Americans off the table. You cannot be Americans. You can never be Americans, was essentially the message. Okay, so from this point, we deviated from the Constitution in regard to Indians. And it was one bad idea replacing the unintended consequences of the previous bad idea. Well, the relevant piece of this decision yesterday goes back to the Curtis Act that was passed in 1898. And what they tried to do, essentially the Curtis Act tried to abolish Indians as a legal status. That was the essence of it. And in doing that, it basically destroyed tribal governments, the ability to govern yourselves, et cetera, et cetera. What happened yesterday was the Supreme Court ruling that essentially the remnants of that law were unconstitutional. I mean, that's the essence of it. So some of the Curtis Act had been rolled back by Richard Nixon, thankfully. Some of it was rolled back in previous court cases like Harjo v. Kleppe. But yeah, what happened yesterday was significant. It was something I never thought I would see in my life. It was a Supreme Court Justice, Gorsuch, looking at the Constitution, taking it at its word, Article 1 and Article 6, looking at the treaty that was signed, and taking the treaty as word and saying, well, this is what it is. There's no fooling around here. There's no trying to mitigate what it is. And so it was very much a return to the Constitution. We have not seen that in a very, very long time.
Now, Keith, what do you make, though, of the fact that it was Gorsuch aligned with the four liberals on the bench, and you have Clarence Thomas, Justice Alito, Justice Kavanaugh, and Chief Justice Roberts all aligned in opposition and dissenting from this particular decision? Because it was 5-4, but it was interesting lines drawn in terms of the ideological makeup, and you normally would find certainly Justice Thomas on the side of the Constitution. So what makes you think that they were wrong?
Well, so I can tell you here. I think the four justices who sided with Gorsuch probably did the right thing for the wrong reasons. But this is really interesting. And this is what was, I wrote about this at some length when Gorsuch was nominated to the court. Gorsuch understands Indian law. He's well versed in Indian law. He is probably the best versed justice in Indian law that the Supreme Court has seen since the Marshall Court 180 years ago, 190 years ago. Justice Scalia, who I have tremendous respect for, Justice Scalia once said, when it comes to Indian law, we're just making it up as we go. This is, if you're an Indian, this is obviously a very important thing. For 98% of Americans, it's trivial. It's not important to them at all. And really, why should it be? It's not something they deal with or think of. And so from a point of view of judges, there are very few judges who are versed in Indian law, very few judges on the federal bench who have any experience in Indian law. Gorsuch, fortunately, is one of the very few, and he was appointed to the Supreme Court. What Gorsuch did was follow the Constitution, and hats off to him for that. Understanding the intricacies here of what are 190 years of horrible federal policy in regard to Indians and voiding the Constitution. And he took the step back to say, we're going to follow the Constitution here. Whereas John Roberts took a more practical view of, well, these are all the bad things or unintended consequences that could happen from this decision. Gorsuch said, this is what the Constitution says. This is what the treaty says. There's no ambiguity here. This is what we'll do.
Again, Keith Noble's our guest, a citizen of the Cherokee Nation, joining us here on Jimmy at the Crossroads once again. So let's talk about some of the implications of this decision. What does this mean? I mean, as we were talking about with our previous guest, Zack Smith of the Heritage Foundation, legal fellow there, this is particularly narrowly tailored towards criminal law and enforcing criminal laws on the Indian territory and the Indian reservation land that now is about half of Oklahoma under this ruling. So what do you view as the implications of this from a practical standpoint, from specifically what this ruling is about? And then we'll get to some of the implications moving forward.
Okay, so it's even narrower than that, Jimmy. and that it only applies to the 5 tribes. So as I mentioned before, George Washington invited Indian nations in to become Americans. Well, before Andrew Jackson revoked that decision, there were 5 nations that accepted that offer. The Cherokee, Choctaw, Chickasaw, Seminole, and Creek, who are Muskogee Indians, the 5 tribes. So those 5 tribes are the only people that this decision applies to. There's 39 Indian nations just in Oklahoma. There's nearly 600 throughout the nation. It only applies to those 5 tribes. So it's even narrower than just law enforcement. It's law enforcement for those 5 tribes. But here's what's important, I think. There's a lot of almost hyperbole about what could change here. In practicality, I think very little is going to change. What has happened here since 1907 is that the state has been able to dictate these matters to the 5 tribes, Cherokee, Chickasaw, Choctaw, Seminole, and Creek. What this decision does is it removes the ability of the state to have to be able to dictate law enforcement matters to these nations. It requires the state and the nations to sit down and negotiate what they're going to do. And so it's a wonderful thing that there'll be cooperation here where there was not cooperation before. And that's a good thing for everyone all the way around. Now, I don't think in practical terms, anything's really going to change here in terms of law enforcement. So, and you're into things that most people have no experience with. But for these 5 Indian nations, they have tribal law enforcement. There is also within their territories, state law enforcement, state police, and then there's local law enforcement for the cities and the counties. Generally speaking, the state, local, and tribal law enforcement, they're already all cross-badged. They're already all cooperating on that level. The only thing here that could change would be the judicial system, and it's highly unlikely that is going to change much. It is probable the tribes will accede to the local courts and the state court continuing to prosecute these cases. But the thing is, they have a voice here. What's been returned to them that the Curtis Act took away is their ability to say no. They have now the ability to say no if they want to.
So you're suggesting here, Keith Nobles, that the practical impact of this decision in accordance with what it actually addresses isn't going to be significant in terms of day-to-day life changes, but what's significant is how Indians will be treated in terms of their relation with the states and the federal government.
Yes, the Indian nations and the state government will have to cooperate now. And where for 113 years they were dictated to. That's the major difference here. That's the improvement in the situation. I mean, that's a major thing. That's a major turnabout in the history of Indian relationships between state and federal government and the Indian nations.
What is the feeling, the sense then for your fellow Cherokee and others of the 5 nations that are particularly impacted by this decision? Is there great enthusiasm?
Oh, people are ecstatic. People are thrilled. We can have a voice in our affairs that we never had before. And even if what the agreement that we make comes to is nearly identical to what it is now, that's not the point. The point is it's cooperation. It's voluntarily reaching an agreement, not being dictated to. And that makes people very, very happy.
So, Keith Nobles, let me ask you a final question then here for every American who's watching this with intrigue about this changing dynamic here. How does this impact liberty on this Free to Choose Friday? What's notable about this decision in that context, in your view, especially as both an American citizen and a Cherokee citizen?
So we're returning closer to the Constitution of the Indian nations being self-governing. And people tend to be almost hyperbolic that they're going to go off and do things, wild, crazy things with that self-governance. And that's highly unlikely to be what happens. What is going to happen is we'll see a greater degree of cooperation here between tribal governments, state governments, local governments. That is what is going to happen. A lot of the hyperbole is just uncalled for, in my opinion. We are going to see greater cooperation, and as a result of that, what we'll see is local people having a greater voice in how they are governed. I also want to say there's a lot of concerns I hear people mention about land ownership and various things, and The majority of people who live on these tribal lands at this point are not Cherokee, Choctaw, Seminole, Creek, Chickasaw at this point. And we have all lived quite well with our non-Indian neighbors in these territories for a very long time. And so I just don't see any issues there. That's not going to change. What changes here is a greater degree of cooperation between government entities. I think a lot of the concerns are probably uncalled for, as well as your previous guest mentioned maybe 2,000 cases have to be reheard. The Indian nations have voiced a desire that the people who have already been convicted of crimes need to face the justice they've already been sentenced to. So there's no cry here from the Indian nations to release any of these people. Many of these people, like Mcgirt, was convicted of a horrible crime. And the sense is he needs to serve his sentence, which is like 500 years for this horrible crime. So the idea here that, Indians will argue these people should be freed is that's just not valid.
Yeah. Well, I appreciate your insights today here, Keith Nobles. Very fascinating perspective that at least in my circles, you're the only one who could really provide that kind of perspective, and I really appreciate it. It is a unique part of American history, also a very sordid part of American history, to be sure, but unique in terms of the dynamics and the relationships and how this has evolved over time and now where we are at this point in 2020. So I appreciate you joining us in that regard.
Absolutely. Thank you, Jimmy.
And before we let you go, let's put up on the screen one more time what people can get at shop.jimmyatthecrossroads.com. Your very own, not yet at peak absurdity, Keith Nobles t-shirt and the camper mug as well. Shop.jimmyatthecrossroads.com. Keith Nobles, model it for us one more time, my friend. There you go. Keith Nobles, everybody, joining us here on Jimmy at the Crossroads. Check out the shirt. Thanks for joining us, and happy Free to Choose Friday, my friend.
Happy Free to Choose Friday.
Thank you. Be sure to check it out. A number of other great things at shop.jimmyatthecrossroads as well. Some other fantastic t-shirts, mugs, a mouse pad for Eternal Vigilance is the Price of Liberty, Thomas Jefferson, and the list goes on. Still Proud throw pillow and tote bag and t-shirt and more. Check it all out at shop.jimmyatthecrossroads.com. Well, that is it for us today on this Free to Choose Friday. I will be back tomorrow. I will be back here on Tuesday. No show on Monday. We'll be back here on Tuesday, live with more engaging, intelligent talk, saying style. And tomorrow I will be on the Jimmy Sengenberger Show on News Talk 710 KNUS. You can listen online, 710knus.com. Be sure to tune in 5 to 8 Mountain Time. My thanks to you for watching and for subscribing at the Jimmy at the Crossroads YouTube channel, youtube.com/Jimmy at the Crossroads. To Zack Smith from the Heritage Foundation for joining us, Keith Nobles, Nathan Matouche, producer extraordinaire. Great to be with you back in the saddle today on this Free to Choose Friday. Remember, we are all free to think, free to act, and free to choose here in America. I'm Jimmy Sengenberger. Have a great weekend, and may God bless America.